Ram Jethmalani's first case was before the Sindh High Court at the young age of 17. The enrollment rule prescribed a minimum age of 21 years, which prevented Ram Jethmalani from starting his legal career at the age of 17. Ram argued his own case before the Chief Justice of the Sindh High Court when he was a student of law, challenging the minimum criterion prescribed by the rule. He passionately argued before Sir Godfrey Davis that his parents would not have permitted him to study law if they knew that he would not be able to support the family for 4 years after graduating, in a sense. It was an argument of legitimate expectations, as we would have perhaps learned to call it several years thereafter. Ram clothed this argument of legitimate expectation with an emotional undertone, and it worked in his favor. Sir Godfrey, who was swayed by Jethmalani's persuasive skills, asked the Bar Council to amend the rules to introduce an exception. It was right at that time, at a young age of 17, that both Ram and those around him realized that he was going to be a formidable force in the legal fraternity and who had the ability to take the courts by a storm. This early display of determination and commitment set the stage for a lifelong pursuit of justice. He came to Bombay, as it was then called, with all but ₹10. Even in his initial years of practice, he carved a reputation for himself as a brilliant criminal lawyer. In 1959, Ram was involved in the prosecution of K.M. Nanavati, Commander K.M. Nanavati. Commander Nanavati was an officer in the Indian Navy, handsome at that, who had settled down in Bombay with his English-born wife and their children. With Nanavati being away from home on long assignments at sea, Sylvia found companionship with Nanavati's friend Prem Ahuja. Sylvia confessed about her affair to Nanavati on his return from his assignment. Enraged by the confession, Nanavati went to the naval base to collect his pistol and then went to confront Ahuja. According to Nanavati's account, he had asked if Ahuja would marry Sylvia and accept their children. On hearing a negative response, he fired 3 bullets, and not unexpectedly, Ahuja just dropped dead. The case was tried by the jury, the last case that we ever tried by a jury in India. The issue before the jury was whether Nanavati shot the victim in the heat of the moment, or whether it was premeditated murder. Ram was hired as a watching counsel by the sister of the victim. His role was to protect the victim and help with the prosecution strategy. There was a great Chari who was appearing in that case. The public prosecutor followed the line of questioning developed by Ram, and theatrical it was. He asked the surgeon on the stand why the victim would start the alleged fight without his glasses on, and how the 2 protagonists could have got into such a scuffle that the gun would go off accidentally with a towel wrapped around the waist of Prem Ahuja, undisturbed. The case was sensationalized, and the jury was overawed with emotions for Nanavati and handed him an acquittal. However, if the judge wanted to send the case to the High Court for reconsideration, they had to prove that the jury was under wrong instructions. A decision of the jury could be overturned on very limited grounds. It was Ram Jethmalani who wrote the brief for the prosecution lawyer, then Mr. Y.V. Chandrachud, pointing out 8 instances of jury misdirection. The argument of jury misdirection was accepted. When the case was heard by the High Court, it found merit in the arguments of the prosecution and convicted Nanavati. But there's a story, there's a sting in the tail, which Ram himself told me about. He said when the case opened, the entire court was hostile to the government pleader, namely Justice Chandrachud, who was then arguing the case. He says on the last day after the conviction had been rendered, Justice Shelat turned to the government pleader and said, "Mr. Chandrachud, so are you pressing for death?" Virtually indicating that if you argue for death, this was a case for the imposition of the death penalty. And we didn't have Bachchan Singh in those days, mind you. And the public prosecutor got up and said, "My lords, I've got the conviction, but this is not a case for the award of the death penalty." And eventually, he was sentenced to imprisonment for life. The appeal against the conviction was also dismissed by the Supreme Court, but he got a pardon thereafter. There really began the friendship between my own parents and Ram and Ratna, which continued almost to the last day of their lives. Ram had the wit and vigor to work within the minute gaps and the gray areas of law. That is what set him apart from the rest of them. As a criminal lawyer, he was known for his art of cross-examination, bravado, and wit. He approached his cases with an investigative lens, an important craft for every criminal lawyer. He would ask for plausible explanations and give an astute psychological analysis of what a person normally would or would not do. Ram had that innate ability in him, which only the best of the criminal lawyers have, of recreating a crime scene. In 1988, he was appointed as amicus curiae to defend the person accused of assassinating Prime Minister Indira Gandhi. The trial court had convicted 3 persons for the assassination and sentenced them to death. The High Court of Delhi confirmed the death sentence. At the Supreme Court, as amicus curiae, persuaded by Ram Jethmalani's argument, a 3-judge bench unanimously not only set aside the death penalty, but also reversed the conviction of one of the accused, namely Balbir Singh. He would call this case one of his best forensic successes. The prosecution evidence relied upon a piece of paper supposedly found in the pocket of the accused with cryptic dates and names. Ram argued on the obvious foolishness of any person in carrying incriminating evidence after a month of the crime when public opinion was so heavily against the perpetrators. Ram gave it his all to prevent the execution of the other 2 accused persons as well. On the counsel of Jethmalani, the accused had petitioned the President under Article 72 of the Constitution to grant pardon, which was rejected. News broke out that the 2 men convicted of assassinating Indira Gandhi were to be hanged at 8 p.m. the next day. However, the hanging was stayed by the Supreme Court just 14 hours before the planned execution, because Jethmalani had raised a constitutional question over the President's refusal to grant him a hearing. He argued that the pardoning power of the President cannot be exercised arbitrarily, and that there must be guidelines for the exercise of this power, because, as he remarked, secret guidelines, he said, are no guidelines. Though he was able to secure a short-term stay of the execution, he was unable to get it set aside. A month later, both the accused were hanged, but Ram's contribution should not be downplayed. He raised seminal constitutional questions in the course of the hearing, which went on to change the legal landscape on the death penalty. He couldn't protect his 2 clients from execution, but he protected the Constitution and the way it has evolved and as we know it today. I would even consider this case as one of the cases which sparked the extensive debate on death sentence in India. During his legal career, which spanned over decades, Ram argued as a defense lawyer in a lot of high-profile cases, such as the Harshad Mehta market scams case, which, by the way, was fortunately the case which led the lawyers' fees to go out of the roof. The Hawala scam, the accused in the Jessica Lal murder case. When he was asked if he appeared for a lot of high-profile cases because it paid him well, he replied, "Of course, naturally," he said. He also went on to say that a lawyer who refuses to defend a person on the ground that people believe him to be guilty is himself guilty of professional misconduct. But Ram also understood that access to justice would be an illusion if lawyers charge exorbitant professional fees or appearances. He recognized the deep inequalities which plagued the society and was deeply concerned about the injustices meted out to the common citizen. By some estimates, he charged only 10% of his clients, and 90% of the cases were handled by him pro bono. I've actually witnessed him in the bar library of the Supreme Court Bar Association, quoting a fee virtually at the back of his hat, or the top of his hat, and asking for a fee of the unstatable. Ram was an amazing mentor. I'll just give you two little examples and I'll then go to the more formal part, and I hope not to bore you beyond that. We were doing a high-profile case and we were appearing for the chairman and managing director of a not-to-be-mentioned corporate group in India. In the Bombay High Court, an excise circular was placed before the court, and it so happened that the circular was fabricated. The judge in the Bombay High Court decided to initiate proceedings under Section 195 and 340 of the CRPC, and we came in appeal to the Supreme Court. And we were against one of the most hostile benches that you could imagine. And it made it worse for us because we thought that both the judges had a slightly pro-revenue stance in their ideology. The first part of the session, the morning session, Ram was subject to a hostile bench. We went back to his chamber for lunch, and we were extremely worried about what the outcome was going to be. So we asked Ram, well, what are we going to do after lunch? So he looked at me and said, for starters, we need to get some chicken patties from Wenger's. So order we did for some chicken patties from Wenger's. I don't know whether it was the patties or what happened, but after lunch, it was just sheer brilliance. Brilliance personified. In about 20 minutes, we had the judges completely turned. And one of the most hostile benches came and said, well, we are allowing the appeal. As Ram evolved in life, many of his lesser-known clients had to go to the lesser-known lawyers because he was no longer fit enough to appear for them. And that's how people like me who were fledglings at the bar picked up the work. He introduced me to the Indian Express work. There were remnants of the work which had remained, the Customs Act cases of the emergency which were still lingering on in the 1980s. And that got me an opportunity to go to Express Towers with Ram's juniors and to prepare pleadings. Criminal appeals. It was a sheer joy to sit with him. To sit with him even while drafting a special leave petition. I remember a case where there were about 14 accused, and he gave me a brief sitting of about 10 minutes to explain to me how a criminal appeal should be drafted, how you must analyze the role of every accused, who are the eyewitnesses, what was the specific act, the overt act which was attributed to the accused. It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times. Thank you very much.